Welcome to Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg. In this series, we'll explore the fascinating doctrines of corporate veil piercing by diving into the real facts from appellate cases that shape business law. This is designed for law students who want to grasp the limits of limited liability, and we'll do this through stories that courts have grappled with over the years. In this episode 1, we'll establish the foundation by looking at what limited liability really means and why the corporate veil exists, how it protects business owners while allowing courts to step in when certain things go wrong. By the end of this first episode, you'll have a clear sense of the basic principles that will carry us through more advanced topics in the episodes ahead, from the specific tests in episode 2 to modern applications in episode 7. Let's start with a cornerstone case that brings some ideas to life. It's called Walkovszky versus Carlton. And this case was decided by the New York Court of Appeals in 1966. Ronald Walkovszky was a pedestrian going about his day in New York City when he was struck and severely injured by a taxi cab. That cab was owned by the Salomon Cab Corporation. But that was only the beginning of the story. William Carlton, the defendant, was a stockholder in 10 different corporations, including Salomon Cab Corporation. Each of these corporations owned exactly 2 cabs, and each carried exactly the minimum liability insurance required by New York law at the time. Beyond that insurance, these corporations had virtually no other assets. Carlton set up his taxi business this way on purpose. The 10 corporations were independent, at least on paper, although in fact, they operated as his one big operation. They shared the same financing, they used the same suppliers for repairs and parts, they employed the same group of drivers and staff, and they all ran out of the same garage. Profits from each taxi company were regularly transferred to Carlton, leaving the corporations as what the plaintiffs saw as no more than mere empty shells that met the bare legal requirements. Walkovszky's lawyers argued that this whole structure was meant to defraud people like him who got hurt in accidents. By splitting 20 taxis into 10 companies, Carlton made pretty sure that if someone like Walkovszky won a lawsuit against one company, there would be nothing left to collect after the insurance paid out. And accidents in the taxi business aren't rare. They happen frequently because of the high volume of riders on busy New York City streets. Carlton not only knew this risk existed, but he set it up so that these risks would not create liabilities between his companies. And the setup meant that the cost of these accidents would land on victims instead of on his own pocket when it exceeded insurance. So the New York Court of Appeals had to decide if this corporate arrangement should be respected, or if it was time to pierce the corporate veil, meaning should we hold Carlton personally responsible or allow Walkovszky to collect from the other companies? The court's ruling kept the door open for such claims if evidence showed that companies were just extensions of Carlton's business rather than true separate entities, but it didn't pierce in this case. It said, this guy set up these companies according to the law. They have separate bank accounts. He keeps separate records, and they all have the minimum amount of insurance. If the state of New York wanted taxi cabs to have more insurance or have more assets, it should have passed a different statute. And by the way, it did later. But it did, again, hold the door open that if Carlton had made one small mistake, commingling funds or not treating these like separate entities, this could have been a case where Carlton was personally liable to Walkovszky. The case shows the balance limited liability tries to strike. It lets people like Carlton start and run businesses without fearing total personal loss from every mishap. But it doesn't give a free pass when the structure seems designed to avoid fair responsibility. That's a theme we'll revisit in episode 6 when we talk about regulatory context. And speaking of context, let's go back to some of the historical roots that led to the modern rules. In the 1800s, business people in England started using joint stock companies to fund big ventures like trading expeditions across oceans and continents. When these ventures failed and left huge debts, some owners tried to hide behind the company structure to avoid paying creditors from their personal money. A law called the Bubble Act of 1720 in England was one early attempt to stop these kind of abuses after big speculative bubbles burst and left investors ruined. A key case from 1897 in the House of Lords was Salomon v. Salomon Co., which helped solidify the idea of corporate separateness. Mr. Salomon turned his boot-making business into a corporation that he fully controlled. When the company couldn't pay its debts, debtors wanted to go after Solomon's personal assets. The court said no. The company is a separate legal person. It's separate from Solomon. Solomon's liability is limited to what he had invested in the company. These historical examples show why the corporate veil was created. It encourages people to invest in businesses, and for those businesses to take risks, and those risks drive economic growth. Without this protection, fewer people would start companies or invest in them, knowing that one bad event could destroy their personal finances. And these are principles that underpin the advanced piercing variations we'll explore in episodes 4 and 5. Now let's turn back to another case that builds on these ideas. Becker versus Interstate Properties from the Third Circuit in 1977, which applied New Jersey law. Gary Becker was a 19-year-old construction worker at a site in Windsor, New Jersey, where a large shopping center was being built for about $1.5 million. Becker worked for Wood Pine Corporation, which the developer, IP Construction Corp., had hired to do the paving work. Wood Pine then brought in a subcontractor called Windsor Contracting Corporation for parts of the job. During the work, a truck driven by a Windsor Contracting employee ran over Becker, crushing his pelvis and causing serious injuries. When Becker looked into who was responsible, he found that Windsor Contracting had only $10,000 in automotive liability insurance. That was far below what was typical for the construction industry, where policies often covered up to $250,000 per accident, and that's because of the high risk involved. The developer knew or should have known that Wood Pine was going to use subcontractors like Windsor, but it didn't check, and it didn't require them to have better insurance or to have financial backing. The result was Becker had very few options to get compensated for his injuries and medical costs. The entity most directly at fault, Windsor Contracting, didn't have the resources to pay, and the developer tried to stay protected behind its own corporate structure. So once again, we had the question, should we pierce? The Third Circuit had to consider this. Was the developer's choice of such a financially weak subcontractor some kind of negligence under New Jersey law? The court thought New Jersey would allow a claim like that and let a jury decide if the developer had a duty to make sure subcontractors were financially responsible enough to cover injuries on the job. And so this case adds another layer to our understanding. It shows how limited liability works in chains of business relationships, like in construction projects where developers hire contractors who hire subs. The protection is there to let businesses organize efficiently. But when it results in injuries to people like Becker being left without fair compensation, courts start looking closer at whether the structure itself is fair. And that echoes the equity concerns we'll see in Episode 3's LLC contaminations. Putting these cases together, we see the purpose of the corporate veil. Laws like the Delaware General Corporation Law and the Model Business Corporations Act make it clear that shareholders aren't personally liable for a corporation's debts just because they own shares. This rule lets people invest in companies without worrying that one lawsuit could take everything they have. The same idea applies to LLCs under the Uniform Limited Liability Company Act, where members get similar protections. The law creates a system where businesses can thrive because risk is limited to what's invested in the company. This is what allows innovation and growth. People are more willing to start new ventures when they know their personal lives are safeguarded. And it allows companies to take on risk, and risk can result in reward and innovation. But these protections aren't unlimited. When owners use the corporate form in ways that seem designed to avoid responsibility for the harm they caused, courts can pierce the veil. This judicial doctrine looks at things like whether the company is really separate from its owners, or just an extension of them, what's sometimes called their alter ego. Factors include if assets are mixed together, if basic corporate rules like keeping records are ignored, or if the company starts with too little money to cover expected risks. In tort cases like Walkovszky and Becker, where people get hurt without choosing to do business with the company, courts seem more willing to pierce the veil to make sure victims aren't left empty-handed. In contracts cases where people voluntarily agree to deals, the bar may be higher because people have a chance to protect themselves, knowing that they're dealing with corporations. As we continue this series, we'll build on these basics. In episode 2, we'll look at the specific tests courts use for traditional corporate veil piercing, using cases like Sealand Services versus Pepper Source to see how fiduciary duties and financial setups come into play. Episode 3 will cover LLCs, with the contamination story from Casey Land and Livestock showing unique risks. Episode 4 will explore reverse piercing through the merger dispute in Vantage Point Venture Partners versus Examine. Episode 5 will examine horizontal piercing, building on reverse concepts. Episode 6 will focus on parent subsidiary companies, and we'll look here at environmental and regulatory cases like United States v. Best Foods and another torts case, Gardamal v. Weston Hotel Co. Episode 7 will look at modern applications like Doe v. Uber Technologies, and Episode 8 will tie it all together, relating common pitfalls, prevention strategies, and a comprehensive recap for students. These episodes will give you a complete picture, always grounded in the real facts from court records. So what are our key takeaways from today? Limited liability encourages business innovation by protecting personal assets. This was seen in Salomon v. Salomon Co. Courts may pierce the veil when structures are abused to evade responsibility, especially for tort victims, like in Walkovszky v. Carlton. Undercapitalization, as in Becker v. Interstate Properties, signals potential abuse in high-risk industries. Tort claims face a lower bar for piercing than contract claims. These principles set the stage for the veil piercing test we'll explore. Thank you for joining me in this first episode. I'm Professor Seth C. Oranburg, and I look forward to continuing this journey with you.